Okay, good afternoon and welcome to Thursday's evening seminar. Today we are joined by Mr. Sharp, Jon Sharp, who's going to be giving us one of his greatly appreciated updates on COVID-19 and the insurers' response. So, as always, if there are any questions, if you could use the Q&A panel in the bottom toolbar to submit those, then we'll put those to Jon at the end of his session. Hopefully most of your questions will have been answered though. He's normally very thorough. So without any further ado, Mr. Sharp, I shall hand over to you. Stun and amaze us.
Well, Julie, I'm not sure I'll amaze you, but there we go. Thank you, Julie. Evening, ladies and gentlemen. There are some updates. I suppose some of you may have come in to this because you want the updates on the FCA against insurers case. But many of you are new, so I'm afraid for those who've been and seen this before, apologies. I still get questions though about the doctrine of frustration, force majeure, etc. So I am going to go through, but there will be updates at the end as to where we are with the FCA case. So I'm sure many of you have read about that. So that's me. Nothing to say about him. His details are all on the website, so please do go and have a look there. As I said, this seminar addresses insurance issues generally. Everybody's policies differ, more about that later, but I can't deal with specific policies unless I'm sent them for me to read. The seminar is as accurate as it can be given the rapidly changing situation, in particular with regard to the FCA insurance case. And I can't address specific situations. You need to speak to your broker, your lawyer, or other advisor. Quick look at the agenda, quick look at Act of God, general information about the virus, most of which we know, but just a couple of points. Office policies, force majeure, frustration, the insurance market approach, mitigation and site closure, travel insurance, recent developments, and the FCA business interruption insurance test case. Act of God, I think we all know this now, but there was a huge fuss when COVID-19 started, everyone saying this was an act of God. This virus outbreak is not an act of God. It's not even going to be considered in the FCA test case because the law is decided on this. Now, the possible causes of this outbreak, as we all know, are consumption of animals outside the normal food chain. That seems to be the established theory. Yes, there are conspiracy theories, to some extent encouraged by the lack of cooperation by the Chinese authorities to have an inquiry, which has been called for by many nations. But it is fair to say that Wuhan did have our equivalent of Pirbright, which is effectively a site that holds specific viruses. So who knows, there could have been an outbreak, but the general theory is it was consumption of animals outside the normal human food chain. But the current law with regard to Act of God is set out in the decision of Lord Hobson in Transco plc against Stockport Metropolitan Borough Council. Lord Hobson gave the definitive definition, which is not just used in this jurisdiction but in others as well. And an act of God is an event which involves no human agency, is not realistically possible to guard against, is due directly and exclusively to natural causes, and could not have been prevented by any amount of foresight, planning, or care. Clearly, COVID-19 is outside of that. What's known about the virus? Well, still very little. There's been speculation that it's not good with heat, it's not good with alcohol, and governments have taken various measures. Our government's response has been pretty consistent with most other governments' responses: containment, delay, mitigation whilst we seek cure. However, one thing is becoming increasingly apparent, that no government anywhere in the world took any precautions to prevent this. George Bush in 2005, not a president that I suspect at the time we held in very high regard, but I think it's probably fair to say is an absolute genius compared to the current incumbent of the White House. Gave a warning, and I've given a link there to it, where he said, he regarded, if you listen to what he says, it's only 4 or 5 minutes, that an outbreak, a pandemic of some description was an inevitability. And he reminded all governments that they need to be prepared for this. Now, no government was. We had no stockpiles of PPP. We had no reports about the ability of the NHS in this country, and indeed authorities worldwide, to deal with the pandemic. We could have cleared up the issue about whether masks are good or not, etc. None of that happened. Insurance policies generally, well, the first and fundamental thing I do want to stress again, and I've stressed this on numerous occasions and I will continue to do so, because the number of times we get cases where people simply haven't read their insurance documentation properly is alarming still. There are 2 parts to your insurance documentation. There is a cover note, and it looks like that. This is in fact this firm's policy schedule for its combined office policy, which covers employers' liability and public liability and covers the office contents. It's a 4-page document, and it summarizes the cover and the amounts that we are covered for in respect of particular heads. But that's all it is. It's a summary document. It is not the policy wording. This is your contract with your insurers. The previous document really only has legally, evidentially, just shows that you had some insurance cover. It is not your contract with your insurers. Any policy wording will be lengthy. Ours that goes with that 4-page summary is some 60 pages long. So that is the document that you need to read. So your cover note only identifies the main terms of your policy. It is not your contract with your insurance company. Your policy wording is. This is your contract with your insurance company, and it needs careful reading by the responsible officer of your company to ensure that it meets your company's requirements. If your business changes anyway throughout the year, including taking on new or unusual types of work, you need to update your underwriters. Your policy wording, if you like, is a living document. So if you suddenly have men working over a height of 150 feet, you need to tell your insurance company that that's what's happened. There won't be a problem. They'll go, that's fine, no problem. In some cases, they might say there's a small increase in premium, but there we are. Let me just stress how important your policy wording is. In 1990, I did a case for Kuwait Airways against their insurers. Now, the wording for that year of insurance had not yet been agreed, but the courts relied on the previous year's wording because it was unlikely to have changed that much. And it was the best evidence the court had as to what the year in which the claim was made's policy would have looked like. So it is a crucial and vital document, and that is the document that you should be reading. Oh, by the way, if you can't find it, if you've gone direct, it will be on most direct insurers' websites. If you can't find it genuinely, speak to your broker if you've gone through one. He should be able to provide it to you at the drop of a hat. Quick look at office policies. Obviously, we're all excluded by our office, by the government from our offices. Now, there were 2 types of cover available under most insurance policies, what's called passive cover or intervention cover. Passive cover basically means that potentially you had cover for notifiable diseases, pandemics, etc. Because most policies that cover your office were intervention policies. If you asked for the most basic office policy, you would have got an intervention cover policy. That covers you for fire, flood, etc. It does not cover you for diseases, etc. Okay? Give you a very obvious example of intervention cover. There is a fire at your premises. Yeah, that causes you to leave your premises. Your insurance policy will repair the damage caused by the fire. And if you had a business interruption extension, it will pay for your basically loss of profit whilst you're out of your premises. Passive cover does not necessarily have to involve fire. It can involve as in the case, it can involve being asked to leave your premises by a local authority or government, and it can also include disease cover. Remember as well, there will be limits on your insurance policies as to how much you can claim, and there will also be an issue as to proving loss, and I'll come on to that a little bit later. Force majeure, well, coronavirus has undoubtedly caused delay to contractual obligations, of that there is no doubt. If a contract contains a force majeure clause, this can excuse one or both parties for performance of the contract if certain events occur. But unfortunately, force majeure has no fixed interpretation in English law, so each case will be individually considered by the courts, unless the circumstances are specifically set out within the contract as to when a force majeure clauses arise. Businesses who think they could be affected by the pandemic should check whether or not there is a force majeure clause. And certainly, let's learn the lessons from what's happened to us recently. When entering into new contracts, businesses should consider whether to include a force majeure clause that operates to the type of business locations in which it operates, so that the reference is made specifically to pandemics and to epidemics. The clause should also include potential government reactions to outbreaks, such as quarantine measures in large cities, closure of public transport, etc. Now, most contracts are entirely silent as to force majeure, including most JCT construction contracts. The words force majeure may appear. That, frankly, is no good to anyone, because you have to go to court to find out whether the event that's happened, that's caused the delay in the contract, is a force majeure event. Contrast that with shipping contracts, where there are, and always have been, significant force majeure clauses defined. So include requirements of government authorities, acts of princes and rulers, import or export bans or restrictions, bad weather, etc. There is a whole list of force majeure, if you like, events. Wouldn't it have been useful if we'd had the same type of definition in our current contracts? So next time you're entering into new contracts, make sure you have a force majeure clause, and make sure that it covers the type of events that has happened recently. I'm afraid I have to say that given we had a SARS outbreak in 2003, 2005, a MERS in 2009 and 2011, and a couple of other nasties in between, okay, they didn't quite become pandemics, but they were very close. I think it's inevitable that this type of situation will arise again. So make sure going forward you have a proper force majeure clause in your contracts. And further than that, you should say in your contract what happens if a force majeure event arises. There's no point in putting in a force majeure event. It arises and everyone goes, okay, it's a force majeure again. What do we do now? You need to define what the parties are going to do. Now, that may simply mean the parties are to meet and then review the contract as to how it's going to perform in the future. But put in there something that says, force majeure event arises, this is what we are going to do. Doctrine of frustration, where there is no applicable force majeure clause, another avenue may be to invoke the doctrine of frustration. So a contract may be brought to an end where something unforeseen occurs after the formation of the contract, through no fault of either party, that has the effect of making it commercially or physically impossible to perform the contract. Now, it might be possible to argue that the pandemic has frustrated the contract, of course, but you have to go to the court to find out whether it has frustrated the contract, and courts are often unwilling to find that a contract has been frustrated because it ends the contract on behalf of both parties. That's it, you both walk away. So, as I said, it would be infinitely better when you're drafting new contracts that you put in a proper force majeure clause, which specifically refers to events like we just had, and also then goes on to say what will happen if a force majeure event actually arises. So did the insurance market come running to our aid in our hour of need for all us business holders? Well, no, we all know it didn't. The insurance market's approach to it was COVID-19 has got absolutely nothing to do with us. Not desperately helpful, to say the least. Anyway, so what potential cover may you have had in respect of delay and cancellation of contracts? Well, look at your business interruption clauses. There are some clauses which will have specifically, though you may not even know it yet, covered the sort of situation we're experiencing. You need to look at your cover for delay of receipt of essential supplies. That is sometimes an add-on to a JCT contract. You may have it, but again, you'll need to read your policy wording. Look at your contractors all risk cover. Again, you can ask for the basic contractors all risk cover, or you may have said to your broker, we want the very best cover we can have. You may find in there that there is some cover for notifiable diseases, etc. In relation to offices, I've discussed that earlier. Okay, but again, it all turns on you reading your policy wordings. What will assist? Well, the fact that coronavirus has now been declared a pandemic and a notifiable disease, that may assist. I'm not saying it necessarily will, but there is no doubt that COVID-19 is both a pandemic and a notifiable disease. However, insurers have argued that this outbreak is not within the reasonable contemplation of their parties and of either party when the insurance cover was taken out. And this is the important point, unless you took out your insurance policies probably before mid to late January of this year, you are now very unlikely to have any cover whatsoever for pandemics and notifiable diseases, because insurers immediately, when COVID-19 became, when Wuhan was locked down on the 23rd of January, and the risk to the world of this disease became more apparent, they went about excluding it from any form of cover. So you must have had some cover in place probably before mid-January. And certainly going forward, it will be virtually impossible for you to get any cover in relation to viruses, pandemics, notifiable diseases in just about every new insurance contract. So I do not wish to depress anyone, but unless you took out your cover before mid to late January, it's probably now long since been excluded. Now, if you are fortunate to have policies that include some kind of cover for pandemic and notifiable diseases, then you still have a duty to mitigate your loss. It's the same duty in all types of insurance policies, to be fair. So it would mean that hypothetically, you can't just close your office, even if the government's told you to, and just walk away. You can't. Certainly in terms of business interruption, you must still continue to operate your business to the best of your ability. Said you can't simply just walk away, say we're covered, we're shutting up shop. It's not how it works. You must continue to operate your business to the very best of your ability in order to minimize the claim that you may be able to make on your insurance policy. Now, I'm going to turn to this because I've stressed it for some time, and I think it's very important. Notification. You must inform your insurers as soon as possible that you may be making a claim. This stage is probably too early to put numbers on your claim in relation to business interruption policy, but you must make a claim as soon as you become aware of it. Now, I'm stressing this because I have heard that a number of people have either spoken to their insurance company direct to simply be told there is no cover, or in one case, a client of mine was told, well, if we pay you, we're going to have to pay everyone. So Don't be put off. Make that claim. If you haven't made it already, you may well run into late notification difficulties because some policies have a clause in there that says you must make a claim within a certain period of time. Now, I would have said by now you will start to run into late notification difficulties. What else should you be doing? Well, you should be communicating continually with your brokers to ask them what you should be doing in the current circumstances, which is a changing picture. Be guided by their advice as to what you can claim for and when you should be claiming it and when you should be notifying insurers as to the potential claim. I'm afraid that's a no clause. If you've not notified by now, then you really should have done so. And also remember that if you shut your site, your offices or sites, even though the government may have told you to, you must tell your insurers and keep them updated. So if you've had to shut a building site for whatever reason, just not practical to get the goods there or whatever, then you need to tell your insurers, because there will be a clause in your insurance that says if a site is occupied for a period of 30, 60 days or whatever, then cover lapses. It's the same with offices. You need to keep your insurers up to date with what the current state of your office occupation is. If you're not there, they will undoubtedly expect you to at least send someone in once a week to make sure the offices are okay. Now, of course, in the city, many offices have got security guards, but they still may say, well, that's not good enough. We want someone to physically access the office once a week and report. So watch out for that. Okay, you must update your insurers as to what's happening in relation to the locations where they provide cover. Quick word on travel insurance, because I get asked this an awful lot. It's very unlikely, as I said, if you took out a travel insurance policy after mid to late January, that you're going to get any cover for coronavirus at all. It will be specifically excluded. If you did have a travel policy before the coronavirus pandemic hit, and do not under any circumstances cancel your holiday flights, etc. voluntarily. Wait until the airline cancels your flight, or wait until the government advice from the FCO recommending not to travel to your particular destination is given. Now, obviously, the FCO recently have changed their guidance, and so you are allowed to travel to different jurisdictions. Spain may have been one of them, and that may account for my ridiculous tan. But wait for the FCO advice. So do not do anything voluntarily, because insurers will simply turn around and say that was your decision to cancel and not something you were forced, you were recommended not to do by the United Kingdom government, in particular the Foreign and Commonwealth Office. So, what is happening in relation to business interruption claims at the moment? Well, at first, I'd hope that the government might intervene in all of this and say to insurers, I'm really sorry, but you do need to be doing something about this. Well, they didn't. Their view was by saying it was a notifiable disease and a pandemic, they had done enough. There were meetings between insurers and the government, but nothing really came of them. So the next we heard was from the chairman of Lloyds. Lloyds of London is a society, but Lloyds of London is still the third largest insurer in the world, either by direct insurance or by reinsurance, which I won't bore you with, but trust me, it's the third largest. His view was, excuse me, as long ago as I think June of this year, of March of this year, he was saying to those who are members of Lloyds, who have got syndicates and boxes within the Lloyds building, that pandemic contagious disease extensions, where such extensions are provided on business interruption or contingency cover, Lloyds would expect this to include losses relating to COVID-19. In relation to policy renewals and extensions, he said that underwriters should be cooperative, and in particular in relation to non-payment of premiums, underwriters should not be cancelling policies simply because they haven't had their premium paid. So he was trying his best to assist businesses in relation to cash flow, but importantly, saying to them that if you have pandemic and contagious disease extensions, he's expecting them to pay. So that was the first indication that we had that there was some dissatisfaction within the market itself about the market's approach to COVID-19. In April of 2020, the FCA wrote to all insurance brokers saying that they were not happy with the situation. And they were stressing that they were expecting clarity from insurers and brokers to customers, explaining clearly and precisely why business interruption in particular was not being paid. In that letter, they said, insurers and brokers have an essential role to play in supporting their customers who may be unclear whether they have the appropriate cover in place. Clear, accurate, and timely communications is crucial, which we expect firms to deliver. The reason the FCA stated that is one of the two fundamental rocks upon which the FCA is founded. That one of them is treating customers fairly, and that includes communicating with them. So the FCA back in April as well were also starting to make noises about what's going on here. Then we had some more encouraging news from some barristers in particular, and I recommend you to it. Geoffrey Gruner of Essex Court Chambers. This paper is on the Essex Court Chambers website. And he considered the following clause: infectious disease, murder or suicide, food or drink poisoning. Loss resulting from interruption or interference with the business in consequence of any of the following events. And one of those following events was subclause C. Any occurrence of a notifiable disease within a radius of 25 miles of the premises. Now, he said in relation to paragraph C, coverage is not restricted to the consequences of an event actually occurring at the insured premises. Indeed, there need not be an occurrence at the premises at all. There is cover if loss is as a consequence of any occurrence of a notifiable disease within a radius of 25 miles of the insured premises. He goes on. As I said, I would recommend this opinion to everyone. By 23rd of March 2020, when the government lockdown was ordered, there were occurrences of a notifiable disease, COVID-19, within a radius of 25 miles of, at the very least, many of the premises insured under this form of policy wording. After all, COVID-19 was a pandemic which was rampaging in most parts of the country by that time. It is apparent that the figures for actual cases of COVID-19 from early March 2020, if not earlier, drastically understated the number of COVID-19 infections amongst the populace. And not only because the many cases were, your symptoms were so mild you didn't notice, but also because of the absence of an efficient and effective testing program. He goes on, and I find this paragraph, this sentence, I still find this sentence very persuasive. Nature does not work in watertight compartments, especially where notifiable diseases spread by viruses are concerned. So it's fair to say that anger grew, not only from businesses, but also just from the general public, whose opinion of insurers is not particularly high at the best of times. And everyone simply thinks this was another attempt by the insurance market to wriggle out of paying what seemed to be perfectly legitimate claims. And the FCA became aware of this anger. Just by way of background, the FCA, as I'm sure many people know, regulate all insurers and all financial industries in this country. And they are a regulator with teeth. This is not your water regulator who fines the water companies £50 if they've been a bit naughty. This is a regulator that can stop businesses operating and can fine them millions and millions of pounds. I think its record fine is 39 billion. It can also order companies to put things right if they get it wrong. And it works hand in hand with the Financial Services Ombudsman. So this is a regulator with teeth. And this regulator likes certainty in the market, and it likes its participants, whether in insurance or in banking, to treat its customers fairly. So it was only a matter of time, really, and I did predict this, to give myself some credit, a little while ago, that there would be a business interruption insurance test case. So what's the background to it? Well, the FCA, as the conduct regulator of insurers in the United Kingdom, has been considering many of the policies in the market and is concerned that there are a significant number of policies where there is uncertainty created by differences of opinion expressed by interested parties as to whether the terms of policies require the claims in respect of all or some business interruption losses are paid. And it goes on. For the avoidance of doubt, the FCA has no intention to retrospectively apply a judgment to in the test case. The question of whether an insurer has acted reasonably and fairly and generally in accordance with its regulatory obligations in rejecting claims will be a matter to be judged against the circumstances at the time. So that's the background to it. That's what it's aiming to do. So how did it go about it? Well, it spoke to some 17 insurance companies and said, we need to work out a framework within which we can sort out whether some or all or none of these policies should be responding to business interruption claims. Now, 17 insurers were asked to participate because they generally had the wordings which have become the subject of some considerable debate. Now, there has to be a process for agreeing facts and indeed assumed facts. The agreed facts will be agreed between the parties as soon as practicable. They did that. The parties agreed a framework of both assumed facts and agreed facts. The FCA then filed its claim form in the High Court, in the Commercial Court, and it said there, and once it filed its claim, underwriters had an opportunity to submit their defence, setting out why they say that there is no cover in relation to COVID-19. I had some concerns at the time whether or not this would be a little fix between the FCA and insurers, but I can assure you it has not been. The FCA, and you can read all of the pleadings exchanged in the case on the FCA's website, have rejected every single argument that has been put forward by insurers. So they agree the facts, they exchange pleadings. There was a series of case management conferences in the Commercial Court, and the short outcome of which is that the case started on Monday of this week. 17, as I said, defendants and the FCA as the lead claimant, acting on behalf of policyholders. There has also been, and the FCA have been very good about this, of consulting with a number of policyholders and asking them to let them have their views as to how the lack of business interruption has affected their business. The reason for the anger, just to be clear, is that business interruption is normally an extension to any policy that you have. It is not, if you'll pardon the vernacular, chucked in for free. You have to pay an additional premium for it. So it's particularly galling for those that have paid some considerable amounts of premium for business interruption cover for it to be rejected. Anyway, as I said, the case started on the 20th of July between the judges, for whom, one of which I had the privilege of instructing when I was much, much younger, Lord Justice Flo. Lord Justice Flo then was one of the barristers to go to in relation to insurance claims. He knows the insurance market. He knows his policy wordings. No one's going to pull the wool over his eyes. He's sitting as well, I believe, with Mr. Justice Butcher, who's also an exceptionally good insurance lawyer. Sorry, an insurance judge. They are currently listening to the skeleton arguments, all of which have been exchanged between the various parties, and are deciding on the case. So what is the case actually going to primarily decide? Well, so four things basically. Certain non-damage covers, notifiable diseases and denial of access should give rise to business interruption cover. So, when the government said you can't go to your offices, open your pubs, open your restaurants, open your cinemas, etc., and when it was named notifiable disease, that should give rise to business interruption cover. Secondly, that the advice, instructions and regulations given by the UK government should be considered together as the authority action and not be separated when considering causation of loss. Where there is no express exclusion for pandemics, no exclusion should apply. And where the policy refers to a vicinity to trigger cover, it is averred that COVID-19 can be found in all areas of the UK and that the policy wordings do not limit cover to loss caused by disease or other trigger only where it occurred within the relevant proximity. Goes back to the point I made with regard to Mr. Gruder's opinion, where he says very clearly that viruses do not work in watertight compartments. I have to agree with that, I'm afraid. Whether or not learned judges will, it's a slightly different matter. I mentioned earlier that there will be arguments about quantum. There will be, if the cases do find that there is business interruption in certain circumstances, in all circumstances, only a few circumstances, bearing in mind that, by the way, there are some 79 different types of notifiable disease cover, then you will need to justify your claim to insurers. And that will mean that you will need to keep detailed records of what you've lost. Now, the case is going to give some guidance as to what you can claim for, so the quantum element. It may say that you can only claim, excuse me, I have to apologise. That you can only claim direct losses. So those that arose directly from the closing of your premises. So, give you one example of that. You had organised a seminar for the week after you were effectively forced to close your office, and indeed the venue where you were holding the seminar was also forced to close. Now that's a direct result of the government action. No argument about it, etc. You have liable to pay the venue for whatever reason. That should trigger a business interruption claim. However, what about just the general downturn in the economy? Is that claimable on a business interruption claim case? That I don't know. It should be, because most business interruption policies are written on the basis of turnover. So if your turnover drops, you should be able to claim the difference in your turnover from insurers. Whether that will be upheld, I'm afraid I can't say. But these are very important cases. They're the first ones to be heard as well that I'm aware of under the new Insurance Act of 2015, which was supposed to make it harder for insurers to avoid claims when there seems, at least at first instance, to be coverage for that set of circumstances. And it's also very important for businesses. Many businesses are teetering on the edge of that, there is no doubt, and they will all be exceptionally interested in the outcome of this case. If you want some top tips, however, these are my top tips, which I wrote down earlier, and now, of course, I've completely lost my piece of paper. But the first one is, if you haven't claimed already, make sure you get your claim in now. You must do that immediately to avoid any late notification points. Do not be dissuaded by your broker. A broker should be there representing you. All brokers should know about this test case. The outcome is highly unpredictable. So the best you can do at the moment is preserve your position. So make a claim. It may well get rejected, to which you simply say, okay, we don't agree with you. We're going to wait the outcome of the test case. You may well also say, insurers may say to you, well, you can appeal to the Financial Services Ombudsman. That's fine. You've got 6 months from the date of the letter to do that, by which time this case will be over. And as to that, the final point I'll leave you with is when a decision can be expected. Well, I would have said by the end of September. There is this matter. There will be a preliminary judgment, I would suspect towards the end of August, and then a direct appeal to the Supreme Court. And I would have thought that will have been heard by the 30th, when we'll all know the outcome to this. But I cannot stress enough that you should be making a claim now. Do not be put off by anything that your insurer says or that your broker says. You get a rejection letter, say, don't agree with you, we're going to wait the outcome of this case. Also, some insurers, and indeed they have the audacity to write to this firm as well, will be saying, well, our insurance policy, it's not actually being considered by the court. Well, frankly, the court's considering an awful lot of things in this case. And I think it's very, very, very unlikely that they won't be considering just about every aspect of this case. So do not be put off by a letter from your insurers saying you're not covered. Say, well, thanks very much, but we'll wait the outcome of the case, shall we? Anyway, ladies and gentlemen, I do hope that's been useful, and happy to take any questions. But equally, if anyone would like to speak to me directly, then please do email me. Everything is on the firm's website. Thank you very much indeed for your attention.
Thank you, John. As always, an interesting walk through the world of insurance and what they will and won't pay for. It appears that you've answered everyone's questions, as we don't have any questions coming in, so thank you very much. But if, as you said, if anyone does wish to contact you directly, Jon Sharp at silverllp.com. Your address to details are all on the slides, and John, as he said, is very happy to answer specific questions. So thank you everyone for joining us. Thank you, John.
You're welcome, Julie, as always.
And we'll speak to you all soon. Everyone stay safe, and hopefully see you all again next week for our next online seminar. Take care.